This is Colin O'Keefe for LXBN TV. EA Sports has for a long time gotten away with including players eerily similar to their real-life counterparts in its popular NCAA football video game. This, of course, was without compensation as college athletes cannot be paid. This practice, though, is coming under much scrutiny as one of those college players is suing the video game developer. Joining me to explain the litigation and its impact is Sekou Campbell, attorney in Fox Rothschild's Philadelphia office, and also author on their blog, the Sports Law Scoreboard. Sekou, first, can you explain the facts and the history of the case here? At the heart of the issue, as I understand it, is balancing First Amendment rights with regulating commercial speech.
The heart of the issue, no pun intended. Ryan Hart is the former quarterback for Rutgers football and took them for the first time in, I think, 20 years to a bowl game. So he has some notoriety within Rutgers, and never really became a pro, but certainly has some notoriety in New Jersey for sure, if not nationally. And he's included, as most Division I football players are, in EA Sports' popular NCAA Football video game, and he was in the mid-2000s, from 2005 to about 2009 is when he played, and those are the games that he was included in. So when you sign up for the NCAA, you have to waive your likeness rights. So it's difficult for Hart to have sued the NCAA for using his likeness. However, he doesn't have that same agreement with EA, and brought a New Jersey common law suit alleging a number of different things. Most of them got dismissed except for the right of publicity claim. Right of publicity claim stayed. It was removed to federal court, where essentially EA Sports, for the purpose of their summary judgment, conceded that they had breached his right of publicity, but argued that they had a First Amendment right to do so. And they relied on a recent Supreme Court decision saying that video games, much like movies and film and TVs, shows and other artwork, had First Amendment protections. It was not exclusively a form of commercial speech. And using that, they prevailed at the district court level, and Hart appealed. Where he just recently, on last week, 2 weeks ago, May 21st, won a 2-1 decision. So there was a dissent in the Third Circuit.
I see. So second, say the courts, and this may even go all the way up to the Supreme Court, ruled in favor of Hart. How big of an impact does this have on the NCAA and amateurism in general? Could people like the makers of jerseys that don't have the name on the back but do have the number, could they get in trouble or owe money to these players?
Right. Well, so historically, in these kinds of cases, there are different ways to address the issue. You can address it legally, or you can address it through, changing the game in some way. Essentially changing the way that they market the game. Depending on how the Supreme Court would rule, if it were to get that far, you would probably see the EA Sports not give up on their business, but change the level of detail that they provide in the game. Of course, that's difficult for them because, as their motto says, if it's in the game, it's in the game. And so if they have to take out what's in the game, that becomes a challenge for them to sell the products, which is precisely the argument that Hart used or it was probably his most persuasive argument in prevailing in the Third Circuit. Now, the Ninth Circuit is considering a couple of cases of former football players as well, and they may use a different test, or they may come out in a different way, which would further the likelihood that the Supreme Court would take up one of these cases. And the second thing I would mention is that the O'Bannon case is looming in the background. As opposed to all these other cases which were against EA Sports, the O'Bannon case is against the NCAA, which brings into play a much more difficult issue, which is the waiver. All college students have to sign a waiver of their likeness to the NCAA. So he has to get over that hurdle. But if he does get over that hurdle, this could truly threaten the NCAA's entire business model, because bulk of their revenue is from the use of players' likenesses on television and video games, etc. So it is a very profound the Hart decision itself is a very profound decision, but its implications throughout the country are going to be felt and argued over the next 3 to 4 years.
Absolutely. As somebody who's played these NCAA football video games in the past, I was always a little bit surprised and always wondered how they could get players so similar to their real-life counterparts in the game without paying them. So it's going to be interesting to watch both this case and the O'Bannon case as well. Again, that was Sekou Campbell of Fox Rothschild. For more of his analysis on this case and on sports law in general, be sure to visit sportslaw.foxrothschild.com. And of course, visit us at lxbn.com, where we have curated commentary from the LexBlog Network's more than 8,000 members, along with hundreds of these LXBN TV video interviews. Thanks for joining me today, Sekou.
Thank you, Colin.